On January 10, 2014, Damon Key attorney Mark Murakami presented a session to the Hawaii State Bar Association's probate law section for the rollout of the 2014 update of the Probate Forms Manual. Mark co-authored the update of the Contested Matters chapter, originally authored by Doug Smith, the chair of Damon Key's estate planning practice group. Other panelists included Damon Key alumna Courtney Kajikawa and First Circuit probate judge Derrick Chan. Find out more at our website, hawaiilawyer.com.
I'm going to talk a little more about amorphous topics. We don't really have forms to talk about the larger scale dimensions involved with contested matters. But you do need to know, I think every estate planning and probate attorney does need to be aware that when you first start off a proceeding, you don't really know where it's going to end up. You have an idea where it might end up. But you always, I think, have to keep in the back of your mind, if someone objects mildly just by filing an objection that the judge is going to handle in a summary fashion at the hearing, or if they object and they raise more factual issues that are going to require an evidentiary hearing, or they object hard and come guns a-blazing and you're going to end up in a contested trial. All these things need to be kept in mind because the civil trial track can happen very quickly upon you. And there are very important steps that you need to do, or the trial attorney needs to do, to make sure you don't prejudice your client. And it's very tough because what happens is you start with a probate proceeding, and then you kind of track, and then you're in the settlement conference land. And so it's like, okay, we'll do a settlement conference, come back in a month, settlement conference, come back in a month, and then, oh, by the way, it's going to get referred out to the civil calendar. You get a trial date, 8 months out. But it's like, well, if you start doing discovery, if you start doing depositions, it's going to get contested, maybe real close on settlement, and you don't want to have the opposing party, who's darn near close to your number, sit in a room for 8 hours with me, fine-tooth combing every transaction they've ever done, every statement they've ever had with the decedent, et cetera. And so I don't think there's any real rule here, but if you do not intend to try the case yourself, I suggest that you have maybe perhaps a couple litigators on tap who can step in, because the last thing that your client wants to have happen is you get to the eve of trial and the case is going to go to trial, and you don't have the discovery and a litigator ready to do it. Courtney comments about this transition from the probate proceedings to the trial proceedings. I recall once, I'll do an embarrassing story. It was literally Wednesday before Thanksgiving, and typically about 1 o'clock, everyone starts kind of filtering out, picking up the kids, going shopping for Thanksgiving. Courtney stops by like 3:30, I think, and I was just finishing my timesheet, logging off, and she says, "Mark, we have a trial. It's probably going to settle, but it starts like in 2 weeks." And the trial judge, it wasn't Judge Hirai, it was referred out to a civil judge. She asked for proposed findings of fact. You don't think we really need to do those, do you? And she said, I don't think anyone else is going to do it because we're in settlement conference every day. No one's got the time to draft the darn decision. And so I said, Courtney, this is the time that you get. It's uncontested. You get to tell the judge before the trial starts what the issues are, what the facts are, what the witnesses are going to say. You don't want to waste that opportunity to convince and make your case. And so she said, I was afraid you were going to say that. And so, because it was due Friday. And so, fortunately, her husband, who still gives me a little stink eye because I stole Thanksgiving away from Courtney that year. But it turns out that we filed on Friday, and we're the only people to turn it in. And the trial, 10 days later, Doug Smith and I are standing there, and it was a multi-party litigation, and we're making all our appearances, and we got the heavy-duty litigator from LA coming out. We got all the big bet the company type lawyers from town, and then Doug and I stand up. We make our appearance, and the judge looked at us and said, Mr. Smith and Mr. Murakami, I want to thank you because you were the only ones to turn in the proposed findings of fact, and you're the only ones to tell me what this case is all about. So, note to self, talk to a litigator, have a litigator on speed dial quick. And we'll have Brandon, I'll apologize to Brandon for ruining Courtney's Thanksgiving from 2009. The other interesting part about this case that I'll tell you about is Colin Gu says that he doesn't do contested matters. Well, I'm here to tell you that I have seen Colin Gu at a trial. UCLA law professor, trust law expert extraordinaire, top 10 experts in trust law in the nation, getting cross-examined by first Doug Smith, which was a treat for me, because I'm his partner, in his cerebral manner, talking about prudent investor and Principal and Income Act. And then comes Colin Gu. And you were impressive, Colin, I will say that. You were very impressive, and he did a great job. So don't believe him, he does contested matters. Okay. First Circuit's a little different from the neighbor island circuits in terms of we actually have a full-time probate judge. So the transfer from probate calendar to civil calendar is a little more formal, I think, in First Circuit. On Third Circuit and Fifth Circuit, Second Circuit, where the same judge is probably going to hear both cases, it's a little more informal. You could probably do it by stipulation, and it keeps the same probate number, but you really need to make sure both parties know when the rules of civil procedure apply and when you're shifting from probate rules to civil rules. At that point in time, the parties have to figure out whether to demand a jury or not. Typically, I would recommend that if you've never seen a jury, you might not want to ask for a jury, but your call. I personally like to have my clients make their own decisions and not judges, arbitrators, or juries. However, there are huge strategic implications of involving a jury and asking for a jury. Once it's been asked, you're there. Not every probate matter carries with it the right to jury. I would invite your attention to HRS 603-21.7. At common law, back in the day, probate proceedings are equitable proceedings, and they are limited to provide equitable relief. Equitable relief does not carry with it the right to a jury trial. By statute, Hawaii has a couple proceedings that are not jury. You don't have a jury right, and some that do. So take a look at that statute. As you're figuring out what claims, if you have some jury claims and some non-jury claims, you're going to have to demand a jury at that point if you want one and pay the, I think it's $350 filing fee to get a jury. Okay. We talked about that discovery. So discovery can be very expensive, and I think that we are on the eve of a uptick in probate and trust contested matters, and I surmise, or posit, as Eric used this morning, I surmise that the reason why this manual is so popular is because I think everyone's kind of expecting that, all the trust, all the houses that were put into trust in the 70s and 80s are now going to get fought over in the 2000s, and so discovery is an important tool in civil litigation to know what the other side's going to say before they say it in court. There's various tools and mechanisms which you can do to figure out what the other side knows and doesn't know, and there's cost associated with those discovery tools. Depositions are a crucial way to know what the other side is going to testify about at hearing, and every litigator is going to want to have a deposition of every adverse witness. Now, if this is a big family and there's going to be 25 people testifying about what Auntie meant when she left that handwritten note on her nightstand before she passed away, that can get very expensive very quick. And so it is important to have it. I think that there's going to be increased pressure on the attorneys to keep discovery costs low because it does get very expensive. Each deposition can run $2,000, $3,000 in terms of prep time, actual time, and the transcript. And if you're not going to go to trial and actually need to have that deposition, then the client's not going to want to pay for it. The converse is all that risk of not taking the deposition falls back on the attorney, because very quickly you could come up to, boy, this case didn't settle like I thought it was going to. We go to trial in 2 weeks. The discovery cutoff, if one was set when it got transferred, could have passed, and I can't take depositions now. And now I have to ask the question of this list of witnesses who I don't know what they're going to say, and what's the maxim? You never ask the question you don't know the answer to at hearing. Because once you ask it, it's out there, the judge is going to hear it, and you've lost control. So I don't know that there's a rule here. These are all factors to consider when you are making the decision whether you want to handle the case yourself or transfer it to a trial attorney. ADR. ADR, Alternative Dispute Resolution, is, and I'm sorry, we're going to exceed our 20 minutes, but it's all because Colin, because he took too long in his chapter. ADR is common. The new circuit court rules require it and give the judges some powers to push people into settlement discussions or into an alternative venue rather than an actual trial, whether jury or judge alone. There are strategic considerations with each type of alternative dispute resolution device you use. There are judicial settlement conferences, and they have pros and cons. There's private mediation with pros and cons, and then there's arbitration with pros and cons. Typically, I don't think we see a lot of arbitrations. I did have one trust fight that went to arbitration, and there's important, crucial considerations to consider before you agree to arbitrate your decision, your dispute rather. First, you have to pay for it, win or lose. Second, it is nigh impossible to appeal an adverse arbitration decision. The statute, HRS Chapter 658A, does provide for 4, maybe 5, bases on which to seek a vacatur of the arbitration award. However, it is in practice very, very, very challenging to undo it. And so be very, very careful before you agree to arbitrate a case. There are some types of cases which I think arbitration is entirely appropriate because the reality is the parties just need to get to a number, a figure, let's say a rent type situation or a property value type situation where a circuit court judge is not going to be equipped and the best person to decide what property value. You might want to have an expert do it, and you can have an expert panel of appraiser arbitrators, non-lawyers even, to decide what the value of that property is for the trust. Judges are experts in the law, and so property value might be something that you might want to consider an arbitration venue. However, this is America, and we all watched LA Law and Law and Order as children, and the right to appeal is ingrained, I think, within our psyches, but as well as our clients. That guy didn't like me, he looked at me weird, and he ruled against me. I want to appeal to the Hawaii Supreme Court. I want to go to the U.S. Supreme Court. The reality is, arbitration, it is nearly impossible. So be very careful before you do that. If you stay with the circuit court to try it, then it's not as impossible. You have a right to appeal by statute and can avail yourself of that. My final point I want to mention is on appeals. If you were so bold as to take the matter from the probate proceeding to the civil proceeding through trial and had an adverse decision against you, then you want to consider, and your client wants you to consider an appeal. Appeals are governed both by statute and by rule, and I would invite your attention to Rule 54B of the Hawaii Rules of Civil Procedure, as well as Rule 34 of the probate rules. Not every order can be appealed, not every judgment can be appealed to the Intermediate Court of Appeals. And I will tell you, as someone who does a lot of appeals, that it is very technical to figure out which document can be appealed and which order can be appealed. In the probate and trust world, only by statute or by rule, only the final approval of accounts for both, it can constitute the final judgment that can get appealed. And so if you have a long ongoing trust, you have to get special court permission and look very carefully at the judgment rules to make sure if you want to cut off the adverse party's ability to object and balk at a later date when the final accounts do go up for approval, you might want to consider getting some type of interlocutory judgment or 54B certification on that judgment to cut off that argument. Because if it's going to be a 20-year trust, you might not want to have to litigate. The adverse party can appeal 20 years later if they don't get a judgment against them. Very complicated. The Hawaii Rules of Appellate Procedure apply. There's certain filing requirements, and it's different forms. And so consider whether you should refer or at least talk to an appeal practitioner if you're going to consider an appeal for your client. The challenge with doing that conversation is that there's a very tight window to appeal an adverse judgment, and that's 30 days. That deadline can get extended under certain circumstances, but we never risk it. If you're going to go, you go. And so recognize that if you're going to call a litigator on the eve of trial, if you're going to call an appeal attorney on the eve of that notice of appeal deadline running, the retainer deposit's probably going to go up commensurate with, if I have to drop everything to take over your appeal because the deadline runs tomorrow, there's going to be a cost associated with that. And so having in the back of your mind a couple appeal attorneys who can handle you work with, you can put them on retainer and not use them type deal. All these are important considerations as you bring a potentially contested matter into probate court.
This podcast has been brought to you by Damon Key, Leon, Kupchak, Hastert. Find us on the web at www.hawaiilawyer.com. Thanks for listening.